3, 2, 1. Ready. Start. From the aforesaid discussion, it is evident that the Senior Citizens Act 2007 has been enacted in order to provide speedy remedy to the aged parents as against the atrocities of their near and dear ones, including their children. Stop. If the parent is aged and old and incapacitated to maintain himself oblique herself, the son or the relative may be held liable to maintain his oblique her parent. Stop. The maintenance can be fixed by the tribunal after making a summary inquiry, and effective measures can be taken to ensure that the same is paid and the senior citizen gets sufficient money to meet his daily need and medical expenses so that he may live his life with dignity. Stop. Further, in case of any harassment by son or relative living in the house of the senior citizen, who subject him, the senior citizen, to mental cruelty or physical torture, he, the son or relative of the senior citizen, would make himself liable to eviction under Section 23 of the Senior Citizens Act 2007, despite the fact that the property in which he is living has been transferred in his name by such senior citizen. Stop. The reason being that the transfer made with the condition to maintain the transferor shall be deemed to be void in case of any such condition. Stop. The word transfer used in Section 23 would not only mean to include actual transfer, rather it would be given a liberal consideration so as to include the transfer of possession to son or relative. Stop. The son or relative living in the property of the senior citizen would be only a licensee who has been allowed to occupy the same out of parental love. Stop. And such a licensee of the senior citizen would be subjected to the proceedings under Section 23 of the Senior Citizens Act 2007 if a case of mental torture or physical assault is found. Stop. Para. The observations made by the court in Om Prakash Manchanda Supra emanates from a dispute which relates to a joint family property and included a partnership dispute. Stop. The provisions of the Act of 2007 were invoked by the father at the behest of his two sons against his third son, and needless to say that the disputes were already engaging the attention of the regular courts, hence the sad order passed in view of its own facts, and the case does not shed much light over the issue which is under consideration of this full bench. Stop. The division bench in Randhir Singh versus District Magistrate, Faizabad and others has held as under. Stop. Para. While passing the impugned order, the district magistrate has gone through the inquiry report submitted by the subdivisional magistrate, and on finding that the petitioner, in spite of having 5 rooms in the house, is living with his elder daughter-in-law on his own sweet will, the matrimonial dispute between petitioner's son and respondent number 3 is pending, and the petitioner has not produced any evidence which could establish that the respondent number 3 has restrained the petitioner from living in other 5 rooms of the house in question. Stop. In the backdrop of the aforesaid fact, the district magistrate has recorded specific findings of fact on the basis of cogent material on record, and the judgment relied by the learned counsel for the petitioner is not applicable under the facts and circumstances of the case. From the perusal of the impugned order, it reflects that the district magistrate, on the basis of inquiry report submitted by the subdivisional magistrate, has recorded specific finding that there is no evidence on record which establishes that the respondent number 3 is trying to restrain the petitioner from living in other 5 rooms of the house in question. Stop. In fact, the petitioner is residing with his elder daughter-in-law on his own sweet will at Faizabad. Stop. In order to protect the interest of the petitioner being a senior citizen, the district magistrate in its order has specifically directed the concerned police station to see both the parties from time to time, and it is also expected from the parties that they live in congenial atmosphere without interfering in the peaceful life of each other. Stop. On due consideration, we are of view that the findings recorded by the district magistrate appears to be sound and reasonable, and there is no illegality or infirmity in the impugned order. Stop. Para. The aforesaid decision would reveal that in the said case, directions were given to the district magistrate to ensure that both the parties live in a congenial atmosphere without interfering in the peaceful life of each other, However, the said decision actually does not state whether any power of eviction has been conferred on the maintenance tribunal / appellate tribunal, hence the said decision also does not throw much light on the issue before this full bench, and thereafter is not of much assistance.